Go ahead.
Hello, everyone. This is Don Bautista. I'm the Executive Director of AC Friends of Court. We help British Columbians complete legal forms. And the impetus to this series called Hello, British Columbians was we noticed when we were doing our client intakes the last month or so, the public has been expressing in so many ways how stressed they are over their legal matters and their ability to access the courts. And so I invited the chiefs of our courts and the heads of tribunals, and sort of the list seems to be growing as we speak, to come and speak to the average person just so that they have a sense of what's going on. So today we have with us Chief Justice Hinkson, who runs the Supreme Court of British Columbia. Chief Justice, hello. I wanted to thank you for indulging me on this request. And the first thing I'd like to invite you to do is just to greet the people and to assure them that, you know, the courts are fine.
All right. I'm not sure I can assure them the courts are fine, Mr. Bautista, but we're doing the best we can. I want to begin by thanking you and your organization for your service to litigants during what clearly are challenging times, and for inviting me to share some of my own thoughts with respect to what we have been able to do and what we would like to be able to do to provide access to justice during the period of the pandemic. I expect we all get accustomed to one particular way of doing things, and once we're comfortable, we're somewhat resistant to changing our ways. I am personally not in favor of change for the sake of change, but I accept always that there can be better ways of doing some of the things that we do. Many of your members and the people you serve will be aware of our capacity to accept filings electronically, as we have been doing for some years. We also recognize, however, that e-filing may be beyond the capacity or understanding of some, particularly some self-represented people, and we have to accommodate them as well as the more computer-savvy people. So presently for filing, as I say, we are encouraging e-filing, but we also arrange for drop boxes to facilitate document filing for those who can't use computers to send material to court. And for some time, we've also accepted facsimiles and even mailed material in cases where an order has been made to allow for that. We're still open to that means of filing. We have been accommodating what are called e-orders for some years now. We have judges regularly assigned to deal with filings, e-orders, and desk orders, and we're continuing to do that through the pandemic. We've also held some video conferences. That is a means that we have used for years now to provide access to justice to some of the more remote areas in the province, and some not so remote, when we can't get a judge or a master physically there. I have heard repeatedly from the bar that while they appreciate our efforts to accommodate them by video, there are strong preferences to be able to have the person who's making the decision in the same room as they are. And I understand that. We can't always make that work, but where we can, I think we will continue to try and do that. The case of each individual is important to him or her, and probably to their families as well. We have simply been unable to treat each case with the same urgency as the litigant or their counsel would desire during the pandemic. Since March 18th, we've allowed the hearing of urgent matters if a duty judge can be persuaded that a hearing is warranted. Some of these hearings have been held over the telephone, but this has proven far less effective than we'd hoped in part because our telephones in the courtrooms have limited capacity and can't accommodate more than 6 callers. We also adhere to what is known as the open court policy. That is, we cannot do our work in private. We have to have the public confident that we're not doing things behind closed doors. And in many cases, the public are represented by the media. And they have asked us to make sure that they're not forgotten in all of this. And so when we have a telephone that can only accept calls from 7 people, the media may not get to the front of that lineup. But we have tried to remedy that by using dedicated phone lines, which will allow more than 7 callers. But we have also been pressing the provincial government to update the equipment that we've been using for far too long. Some of the hearings to date during the pandemic have been conducted exclusively in writing, not unlike what we have done for years with summary judgment applications. But as many litigants know or learn, it's not always possible to determine the factual foundation necessary for the determination of the issues that may require viva voce or oral evidence. We have started small. We're dealing with single issue disputes for the present with written submissions. Last week, we had double the number of applications for written argument than we had the preceding week. And so we think the uptake is going to be there and going to continue. We have turned to greater use of video for hearings during the pandemic, but we have not as yet embraced that for cases where oral evidence is necessary. I think most of us believe that we can better understand and better weigh evidence if we actually see the person in the room giving the evidence. There are problems with security of the evidence. If we're simply looking at a screen, we don't know who's standing behind the camera helping with the evidence, as we would not allow in court. So that has been a challenge. We have very few video machines available to us. And again, we've been asking for years for better and more equipment. We have run last week 3 test cases using the video equipment we have, and things like the Zoom platform that you and I are on today. We're going to continue to do as much as we can, short of oral evidence, with that kind of technology. And the Attorney General has indicated that he is willing to try and get us immediate funding for some additional video equipment. We've been attempting to resume at least some of our trial work, and I hope to be announcing sometime this week that we are going to phase back into trial work and try to begin the trial work the week of June the 7th. Before we can have trials in civil and matrimonial cases, there have to be pretrial hearings and conferences so that we can be satisfied that cases are actually ready to go. Because we have a limited number of judges and an even more limited number of courtrooms, the provincial government sent people in last Friday to Vancouver to look at the courtrooms to ensure that we're able to provide appropriate physical spacing. But we have problems as simple as taking the oath. We can't use the same Bible for a series of people. We can't sit them in the same witness box unless it's been sanitized. We have challenges with the use of documents. They're even greater on video hearings, but in the in-person hearings that we'd like to resume, we have to deal with the reality of potentially contaminated documents. We're not sure how much take-up we're going to get if we offer trials again. I know that many British Columbians who have children of school age now have those children at home, and their ability to attend in court has been compromised, and the limited number of daycares available further compromises that. We also have cases where people need to travel from one part of the province to another, or even from outside the province. And I think it unlikely we're going to be able to expect people to come from another location, even within the province, unless they can travel safely. And when they get to wherever we're going to have the hearings, if they can have a place to stay, if they need to stay overnight. My wish is that we can make access to the courts available throughout the province. We, in our courts, sit in 28 different registries. We only have resident judges in less than half that number. I can't ask my judges to get on planes right now. So we're going to have to be creative with hearings outside of the Lower Mainland and the hubs where we have resident judges. Well, I agree that technology shouldn't be a hurdle. We are reliant on the provincial government to fund equipment that we need. And I think the attorney and his ministry have tried to respond to our needs, but we're all playing catch up now. And there are not many winners in a game of catch up. We expect, I don't want to say we welcome it, but we expect criticism of many of the things that we do. And it's not that criticism is unwelcome for us. We believe we can do better. But what has been disappointing to me is the number of members of the bar who have stepped forward and criticized us for our failure to use technology. They don't tell us what technology they'd like us to use. They don't tell us who's going to pay for it. They don't tell us who's going to be using it on the other end, whether it's going to be useful to litigants, whether the lawyers are going to understand how to use it, but they're quite free to complain. And I don't find that terribly productive. We are looking for constructive comment, constructive advice about the innovations that we should be considering. And we certainly do consider and often receive advice and suggestions from bar groups and advocacy groups, and we will continue to rely on them to give us that advice and their criticisms. One way for non-lawyers to have a voice on changes in the way we do our work is to contact Access to Justice for BC, which is chaired by Chief Justice Bowman. And Associate Chief Justice Holmes of my court represents our court on that committee. And it also includes representatives of what some refer to as stakeholders in the legal process. We do endeavor to keep the public up to date with the workings of our court through our website, which is regularly updated as changes occur. And as I say, I'm hoping to make an announcement today. I hope that my comments will have gone at least some small way to ease your concerns and those of the people you serve. And we'll continue in our efforts to provide you and your clients with meaningful access to justice as we go ahead. So I want to thank you for giving me the opportunity to share some of my thoughts at least, and I'm happy to take any questions you'd like me to answer.
Thank you, Chief. That's a lot of empathy from you. I mean, it's rare that I would hear you, but you've got me, sir. That's a lot of empathy from the Chief Justice of the Supreme Court. And I have to say that the people of British Columbia would be heartened by what you had to say, because there's a lot of considerations. And you're right, changing innovation just for the sake of it, that hardly seems to be sensible. But in the light of having to take care of physical distancing and for the care of the people who have to attend to their business in the courts, you've certainly shed those lights. Now, moving forward, lessons from the pandemic. What can you share with us? What are you thinking of there will be a new normal, as everyone says. What do you see?
Well, I don't see a big change in what we do inside the courtrooms. I know that there are those who feel that online handling of legal issues is the way of the future. I'm not persuaded that that's necessarily so. I'd be happy to be persuaded, but I would need to know what specific technology is going to be available, how we would use it. We have to train our court staff and our judges, and the lawyers have to have somebody train them if we're going to make significant changes to the way we do our work. Certainly getting people ready for hearings could be assisted if we had the kind of technology that we've been developing and working with. We do have a difficulty with two of our platforms. We need both of them, and they don't communicate with each other. And it's another matter we've raised with the provincial government so that we could streamline the two platforms we use. Unfortunately, one of them we have to keep very secure because of what's in there. And so we don't want to make it available to all of the users of the other platform. So a lot of planning needs to go into that. But from a practical point of view, if I have a judge who's sitting in Fort St. John and the work there has to be adjourned or settles, we could ideally have that judge hear something from Campbell River. But the judge can't access the court file on the equipment we have in Fort St. John from Campbell River. And so we have to have staff download it and scan it and send it to the judge. It's a very time-consuming process and is not an effective way of administering justice. So we've been looking for some time at correcting that, but so far we haven't had the pressure we're presently having to remedy that situation. Now that we've got the pressure, I expect we'll be looking at that more quickly. So I don't think, I think it's early days for us to say things are going to be dramatically different. There are all kinds of bodies and groups who are now insisting that things must all change. As I said earlier, I'm not opposed to change, but I need to be persuaded that if we're going to abandon something that has served us well for a long period of time, we have to be able to offer something better.
Now, perfect segue. So the paper-based system will continue, and that's great for people who are not able to use computers, for example. That Zoom is now sort of part of us, or is that what you're using as opposed to like?
Well, we're not. We're using Teams that the provincial government prefer. We experimented with Zoom, and Zoom is being used by the Court of Appeal. There are various varieties of Zoom. Some of them pose security issues for us.
Right.
And we have to always be conscious of the record that is being created because it can't be reconstructed. Most judges either have their own laptops in the courtroom, or some of the judges less comfortable with technology like me take written notes. And I'm pretty good at taking notes, but I often will listen to a particular witness or a particular piece of evidence on our audio recordings just to be sure my notes are accurate. And if we don't have that kind of a record, you revert back to relying on my notes. As I say, they're pretty good, but every once in a while I'd like to be able to confirm them.
So whether it's Zoom or Teams, I guess from the outside looking in, it certainly becomes another portal in terms of access to the courts. And as you say, it's early days, and there might be things that can be done using this platform as a way to continue to access your courts. And there are many, as I'm sure you're aware, benefits to not having to travel down to courts. And I speak on behalf of our clients, many of whom have children at home and are single parents. So I wanted to sort of raise that. And on that vein, family law matters. It's a big part of your business. And there's a subset there that we kind of feel, anecdotally at least, that there are many victims of gendered violence out there, and yet they're not coming out because they can't come out because of COVID. And they certainly pose a serious concern in terms of how they're going to navigate this when you start opening up your service. Is there any comments to that?
Well, family violence, unhappily, is not an uncommon factual matrix that we see in our court. And I think probably more so in the provincial court. As you know, we share jurisdiction with the provincial court. We can hear any aspect of a family case in our court. The provincial court can hear matters involving custody and access and some spousal and child support, but they can't deal with property issues. So if it's the house that needs to be sold, it has to be ordered by our court, and they can't grant divorces. Many other jurisdictions have unified family courts so that it's kind of one-stop shopping. Mm-hmm. And there's a lot to be said for that. But the difficulty is my court has 91 full-time appointments and some supernumeraries. The provincial court has more like 140. And they sit in more locations than we do. So that is a little more attractive, I think, for some people. The chief judge of the provincial court has, for at least the last 5 years that I'm aware of, been working to try and create means to resolve family issues that allow people to avoid going to court, using family counselors and non-judicial people for cases where a solution seems reasonably obvious. But people still need to have an independent arbiter decide matters that they feel they have the right to come to court to get resolved. And as I say, the chief judge of the provincial court has really done good work in creating avenues for people to allow them not to have to come to court for things that don't need a judge to decide. But short of stopping family violence, there's no answer other than to accommodate people as best we can. And unfortunately, that often means having them come to court.
Okay. Urgent and non-urgent matters. You've said that your colleagues have been sort of, when rejections are made or when a decision is made that a case is non-urgent, what's happening these days is not to give reasons for it. And I want to raise the plight of the self-represented litigant who sees their case as urgent, as important. And can we talk about this, the approach that you've taken, and decidedly, I guess, if someone was represented, they have that advantage of being able to fine-tune how they're presented to the courts, increasing their chances that they will sort of get a hearing sooner than later. And it leads to my question about generally procedural fairness during these times.
Well, we have limited capacity even now, so we had to decide which cases had to be given priority. Ideally, we give every case the same amount of priority. And I know during regular times, because of the vacancies we have in our court, I would often have all the people who didn't get a judge brought before me on Monday morning and explain to them that it's because we don't have enough judges their case didn't get heard. But the week before, I had to decide which ones did get heard. And every litigant's case is important to him or her. I understand that. We have some constitutional obligations and some obligations created by the Supreme Court of Canada decisions that give some priority to criminal matters. When I decide whether a criminal matter or a family matter or a commercial matter, or personal injury matter is going to get a judge assigned or not, I don't necessarily favor any one particular kind of case. Certainly if it's a criminal case, we run the risk, if we don't provide a judge, of having to stay the charge. And in cases where there are victims involved, they're very unhappy with that prospect. Fortunately, we haven't had to do that in British Columbia very much. But we have that sort of looming behind us. But we then have cases where families need to know where their children are going to go to school in the next year, who's going to have them, how are they going to get financed, where are they going to live. I don't think that's less important than having a criminal matter resolved even with a victim. But then you get to the business cases where, and there are going to be a lot of them coming up now, where a business is going to be in serious jeopardy and may fail if their problem isn't sorted out by the courts. And that is going to have a ripple effect through the economy. And then finally, there's the personal injury cases where a breadwinner is unable to work and care for his or her family. They need an answer. And how do we choose between all of those competing interests? There's no perfect answer. But we have to make decisions. And I suspect very few people, if they're told your case didn't get a judge because the Chief Justice felt something else had to go ahead first, they aren't going to care why I didn't do that. They care that I didn't do that. And it is very difficult and painful for me to have to tell people that their problem is not going to get addressed as quickly as they would like. But we have limited resources, we have limited judges, and many competing litigants. And with the backlog we're generating during the pandemic, it's going to just compound all of those difficulties. And we're going to have to ask some people to be a little more patient.
Well, I have to suspect that when you were appointed Chief Justice, there wasn't in the job description to do your weekly apologies to people that weren't going to get their cases heard.
If it was, I didn't see it.
Right, because I remember the day you were appointed, sir. I just don't see this, but I wanted to allow you exactly why this interview was had to take place. Unfiltered. You were able to explain to people why and how hard it is. And media doesn't necessarily put that in that perspective. So thank you for sharing that. That leads me to my last question. Lawyers are very powerful insiders. They're members of the bar, and through them and the regulator, there's enough sort of a pipeline that you guys can reach out to bar associations or the law society to say, all right, this is what's happening. And that's disseminated to the profession. The average public doesn't have that. And okay, we can drop A2J BC Align as you suggested because you have somebody there. But is there anything else that you can suggest?
Well, as a matter of principle, when new judges are appointed to the Supreme Court of British Columbia, I sit down with each of them and I explain to them that part of their job as a judge is to take place outside the courthouse, that we have to be available to go and speak to groups, whether they be students, whether they be activists in some area, We're not allowed to offer political views. That would be wrong. But I do encourage the judges and masters in the Supreme Court to go out to the community, to make themselves available, to answer questions, to give talks, to put a face on justice that hopefully will be a little more welcoming than the somber image that most people have of a sitting judge. I think it's part of our job, and if people want to have a judge available to come and talk to a group, often those requests come through my office, and I encourage my judges, and I can't think of any of them who are not prepared to go and deal with interest groups and public groups. Some have a bit better understanding of a particular type of problem than others, and so we're not all good at everything. But if I get requests, as I say, I will encourage a judge to go and speak. And I think most of us find it quite rewarding to get out in the community and talk to real people.
Chief Justice, I've run out of questions.
All right.
So it leaves, I would like to leave you the opportunity to have last words before we say goodbye.
Well, I have to say that during this period of such difficulty, our staff have stepped up in ways that, on the one hand, I kind of expected of them. They're good people, they work hard, but they've exceeded even those expectations of mine and have allowed us to do what we can. Many of them are working well into the night trying to come up with creative solutions. Our IT people have been available at a moment's notice. The judges and masters of the court, I know, are anxious to get back to more work than they're doing. So we will continue to try and serve the people of British Columbia as best we can, and we all appreciate that that's our role.
Well, on that note, Chief Justice Hinkson, I have to say I have not seen you in a long, long time, but I wish you well. I feel the weight on your shoulders, but I certainly appreciate the candor you shared with us, the empathy, and how you started our conversation today. And I have many friends in your court, sir, and I wish them well as well.
Well, thank you.
All right. Goodbye, Chief Justice Hinkson.
Goodbye.